Hi everyone, in this week's dispatch video we are starting with possibly the most inventive headline that I have ever come up with: in with the old, out with the EU instead of new. So we are focusing on the removal of some EU legislation as the government had promised. A number of consultations had taken place during the course of this year, and the aim was to look at whether the government wanted to amend certain rights which derive from European law. On the 8th of November, the government reacted by publishing the draft Employment Rights, Amendment, Revocation and Transitional Provision Regulations 2023 to implement a number of proposed changes which are likely to take effect very soon on the 1st of January 2024, subject to parliamentary approval. So we're firstly going to look at certain rights which derive from the working time regulations. So these regulations govern holidays, entitlement to periods of rest, weekly rest, 48-hour working limits. And firstly, and fairly trivially, the government will amend the regulations to provide that employers do not have to keep a record of the daily working hours of all workers if they are able to demonstrate compliance without doing so in such manner and format as the employer reasonably thinks fit. So a loosening of the requirements to record working hours there. We then move on to some really important changes which are a response to a number of decisions in the European Courts of Justice which the government have seen fit to finally address. So just a bit of background: there are two sets of statutory leave in the working time regulations. Regulation 13 leave, which is 4 weeks of annual leave in each year, and then an additional 1.6 weeks of leave under 13A. Now they're currently required to be paid at different minimum rates because we had some case law in Europe which focused on the issue of regular commission, bonuses, overtime, allowances, and it was determined that in many cases those payments had to be factored in to the calculation of average holiday pay for the first 4 weeks of statutory leave in the year. So the government is now legislating to clarify what should be included in holiday pay for the purposes of Regulation 13 leave only, so just the first 4 weeks of statutory leave in that year. And it is generally reflecting the case law, so payments including commission intrinsically linked to the performance of tasks that the worker is obliged to carry out will be included in the calculation of holiday pay. Payments for professional or personal status relating to length of service, seniority and professional qualifications, and payments such as overtime which have been paid regularly to a worker in the previous 52 weeks will need to be incorporated in average holiday pay. So anything on top of the Regulation 13 leave, anything on top of 4 weeks, can continue to be calculated on basic hours only. So that two-system method of calculation will continue to apply, unfortunately. We then have new holiday rules for irregular hours and part-year workers. So they will be excluded from the existing right to holiday under Regulations 13 and 13A. This comes from case law which really skewed the system in terms of calculating holiday pay for, in the particular case example, somebody who only worked a certain number of weeks of the year. In my view, they benefited unintentionally more than a full year worker by being entitled to 5.6 weeks of leave. So the government has reversed that position. Firstly, an irregular hours worker is someone who is working a variable number of paid hours in each pay period. A part-year worker is somebody who works part of the year and where there are periods of at least a week where they are not required to work and for which they are not paid, ignoring sick or statutory leave such as maternity leave. So these types of workers will instead be subject to new regulations 15B to 15F of the working time regulations. So this will provide for a new holiday entitlement where accrual is based simply on 12.07% of the hours worked in the previous pay period. So that's all the employer will have to do. They won't have to look at average earnings, they won't have to go back 52 weeks. They simply take the hours that have been worked in the pay period, multiply that by 12.07%, and that gives the accrued holiday rate. Now, interestingly, employers will be allowed, if they choose to do so, and if they contractually agree with the employee, to implement a system of rolled-up holiday pay. And so this was deemed to be unlawful many years ago after introduction of the working time regulations. But again, they can uplift normal pay by 12.07%. I expect they will have to still separate that out on the payslip and make it contractual, but they will be entitled to operate a system of rolled up holiday pay, which means paying that to the worker at the same time as their normal pay, rather than it accruing as leave and being paid at a later date. And that will only apply to leave years that start on or after the 1st of January 2024. Final bit of news on holidays, and that's simply that the rights which have accrued, again through case law over the years, will be codified. So just put into the legislation a maximum of 18 months of accrued Regulation 13 leave, so that's 4 weeks a year, can be carried over where a worker is unable to take this due to sickness. All leave can be carried over where an employee can't take it because of being on maternity or statutory leave, and there are some other provisions there about carryover as well, which are a little bit less common, so I won't go into those. The final piece of news for the 1st of January is in relation to the reform of TUPE consultation. So aside from micro businesses, so those with under 10 employees, transfers or either service provision changes or business transfers require a certain level of consultation, and unfortunately the election of employee representatives where there is no standing body. The government will proceed with its proposal to remove the requirement to elect representatives for businesses with fewer employees or businesses of any size where there is a transfer of fewer than 10 employees, which I think is very sensible indeed. That will allow direct consultation with the employees where there are no existing representatives in place. That is likely to affect transfers taking place on or after the 1st of July. So a lot to digest there. As I say, the regulations are only in draft form at present. Assuming they pass through Parliament, they will come into force on the 1st of January, and for TUPE transfers probably after the 1st of July. We will keep you updated on this as it progresses, because it is a number of important changes that we finally have following our divorce from the European Union. In the meantime, if you need any further guidance or support, please do get in touch. Visit the website chadwicklawrence.co.uk or email employmenthub@chadlaw.co.uk. Thank you.